Mr. Nelson,
To file a notice of payment. Nobody else but his person.
what is that? Oh, he can't be on the phone in the courtroom. Jefferson County Court, law number 2 is back in session. The court is in session in cause number 26 CCCR 0846. Case is styled the state of Texas versus Hazel Root Nelson. We have Ms. Nelson in court. Ms. Nelson, is that your full name? Ms. Nelson, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Ms. Nelson, you may put your hand out. How are you doing, Ms. Nelson? That's good. Now, Ms. Nelson, you're represented in your case by your attorney, Nathan Reynolds. And Attorney Reynolds, how are you doing?
Doing well, sir. Thank you.
That's good. And the state is represented in this case by Attorney Denise Williams. Ms. Williams, how are you doing?
Very well, thank you.
Ms. Nelson. Well, Mr. Reynolds, do you waive a record in Ms. Nelson's case?
Records waived.
Okay. Ms. Nelson, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Hazel Root Nelson, on or about January 17th of 2025, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of drive while intoxicated. Second, state, are you abandoning the enhancement paragraph?
That is correct, Your Honor.
And Ms. Nelson, the state is abandoning the enhancement paragraph. And what that means is instead of being charged with a Class A misdemeanor DWI, you'll be charged with a lesser included offense, which is a Class B misdemeanor offense of DWI. Do you understand?
Yes, sir.
And to the Class B misdemeanor offense of driving while intoxicated while you operated a motor vehicle in a public place in Jefferson County, Texas, on or about July 17th of 2025, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Okay. Now, Mr. Reynolds, the box that needs to be checked is the box below that one. It's the DWI first box. It is also a Class B
Oh,
misdemeanor.
yes. Okay.
Okay. Now, Ms. Nelson, I have before me a document that is titled Misdemeanor Plea Admonishment This document is also labeled as State's Exhibit number 1. And you notice that there's one box that's checked on the first page. The box that's checked states that this is a DWI first, which is a Class B misdemeanor. Range of punishment is minimum 72 hours in the Jefferson County Jail to a maximum of 180 days. Or you could be given a fine up to $2,000. You could be in both such fine and confinement. Do you understand the range of punishment for a DWI first, Class B? All right. On page 3 of this same document, there's a set of initials. There are a set of initials, HN, on a line next to a box that check guilty. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there is a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
On the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled Discovery Certification. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Ms. Nelson, before you sign and initial to these documents that I'm showing you, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes.
Ms. Nelson, are you a citizen of the United States?
Yes, sir.
State tenders to this court, State's Exhibit number 1.
Any objections?
No objection, State.
No objection. States Exhibit number 1 will be admitted. Mr. Reynolds, you've advised and counseled Ms. Nelson. Is there any evidence that she is currently mentally incompetent to stand trial?
None to my knowledge.
And Ms. Nelson, your attorney, Mr. Reynolds, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
And Ms. Nelson, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The essential terms are as follows, Your Honor. It would be 180 days jail. However, there will be probated for an 18-month period of time. There will be a $300 fine, 6 hours community service, and an interlock device. Is that correct, Mr. Reynolds?
Yes, along with the other conditions, alcohol assessment and DWI education.
Okay.
With due consideration by the state given to Ms. Nelson, Your Honor. And that she's been working an incredible program.
Okay. Hmm. And Mr. Reynolds, were you appointed in this case?
No, I'm hired.
You're hired? Okay. What's the court cost?
$392.
Okay. Ms. Nelson, state is offering that you serve 180 days in Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 18 months. During the 18-month probationary period, you'll be required to pay a fine of $300 plus court costs of $392. You'll also be required to pay a DWI conviction fine fee of $100. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is a total amount that you will be required to pay each month while you're on probation is $127 a month. Will you be able to pay the $127 each month?
Yes, sir.
You'll also be required to perform 60 hours of community service, install an interlock device on any vehicle that you own or operate, attend and complete the DWI education class, have an alcohol assessment, and adhere to the other standard terms of DWI probation. Ms. Nelson, do you understand the state's offer?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Nelson, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Nelson, this will conclude your case. Now, Ms. Nelson, you're gonna stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go. And Ms. Nelson, I think the prosecutor mentioned that you've been participating in a program. I'd like to commend you for your participation. You know, the first step to recovery is taking that first step. And so you're not just on the finish line, you passed the finish line. Well, you passed the starting line, okay? And so I'd like to encourage you just to keep on progressing on your journey. And I mentioned the starting line because the road to recovery is not a sprint, it's a marathon, it's like a race. And you know anything between the difference between a sprint and a marathon? A sprint is a short race. A marathon is a longer race. And I know that, you know, when you run long distances, you get tired along the way. But if you get tired along your journey, just remember, you have people that you can lean on. You have people that you can lean on. There's people who are not only lean on, but they're cheering for you. Okay, you have individuals who are, you know, AA in the AANA program that you can lean on. You can lean on your probation officer and other people. I'm sure you have family members as well that you can lean on. But I'd like to commend you for getting on this journey to recovery. And we'll be praying that you continue to stay on it. And I believe that you will finish. You know, they say the race doesn't go to the swift or the strong, but it goes to the one that endured until the end. And I believe that you're going to make it to the finish line. Okay. And again, just continue to hold on. Don't hang up. Okay. And you have a blessed day. Okay. You're welcome.
Good to see you.
And Miss,
Williams.
okay, you have a blessed day as well.
Thank you.
Okay. Miss Mosby, Miss Mosby, she's gonna, you're gonna print her over here. Yes. Okay, Ms. Morton, would you come on up to that first set of chairs? You're gonna walk all the way to that first chair, all the way on the end. Mr. Driver, you're gonna sit next to Ms. Fortin. You can sit down. Mr. Nguyen, you're gonna sit next to Mr. Driver. Ms. Levens, you're gonna sit next to Mr. Nguyen. Mr. Martinez, you'll sit next to Ms. Levens.
Oh, yeah, yes, sir. Number 8. I'm terrible with pronouncing names. That's your vote. I wrote the first name.
You said eight, right?
8, yes.
Trejo,
Matthew.
you're gonna come to this first set of chairs, right up here, and then you're gonna sit over there on that first chair. Go up, this first set, go all the way down to right there. You're gonna sit right there, yes. Matthews, you're gonna sit next to Mr. Trejo. Mr. Romero, you're sitting next to Miss Matthews. Oh, Miss Dejon, you'll sit next to Mr. Romero, right here, right on the first row. And Miss Dickerson,
Yes.
there's a seat between, right here, there's a seat between you and Miss Dejon, right there. And Miss Dyson, you'll sit next to Miss Dickerson. Mr. Smith,
Yes.
you're gonna go down that second row and go all the way to that first chair in this first group of chairs. And Mr. Thomas, you'll sit next to him. Miss Samuel, you'll sit next to Mr. Thomas. Is that Absher? You'll sit next to Miss Samuel.
Yeah.
Mr. Arsenault, just follow Mr. Abshire, you sit next to Mr. Abshire. And Ms. Jennings, you'll sit next to Mr. Arsenault, just follow Mr. Arsenault.
I think I love this crew. It's so funny.
Yeah,
They're so funny.
we had forgot to put one on one of those chairs. That was the one excuse. Okay, you may be seated.
12.
You may be seated.
I'm sorry. I will focus on business.
Okay. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. I'd like to apologize to you for our late start, but while you were outside, we had some legal issues that need to be taken care of while you were there, and you could not be in here while we was taking care of those legal issues. Again, my name is Judge Terrence Holmes. I'm presiding judge here in County Court at Law number 2. You have been asked to come to court for service as a juror in a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, the first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is a minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, which is the highest felony, if they are convicted, the minimum is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type punishments because, as I mentioned to you earlier, the case that we have in this court is a misdemeanor case. Now, misdemeanors are divided into three categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Class C misdemeanors are cases that start in the city court or the JP court. For example, a traffic ticket, not having your seatbelt on, or having an expired sticker. Those are Class C misdemeanors. Now, the range of punishment for a Class C misdemeanor is fine only. You cannot be given jail time. You only can be given a fine that does not exceed $500. The next highest misdemeanor is a Class B misdemeanor. And with the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail or a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor, and the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year, in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you will be examined for inclusion in a criminal case, this misdemeanor criminal case. Our courtroom hours normally vary, and the hours are normally from 9 a.m. to 5 p.m. Now, in this court, we usually have dockets in the morning. A docket is a list of cases that we have. For example, this morning we had 3 dockets. We had a jury trial docket, and then we had an announcement docket, and then we had what is called a pretrial conference docket, where individuals will have their cases put on a pretrial conference. So we'll hear motions prior to trial. Announcement docket is where the attorneys will come in and announce whether or not they want a trial or whether or not they need more time to prepare for a trial. Or they can announce that they have reached an agreement in the case. Trial docket is that we had our jury trial docket, and now we have the case that we had. One of the cases that we had set this morning is set today. Now, whether or not you're selected as a juror today or not, you are performing a significant service which only free people can perform. If you are selected, the case will be tried expeditiously, consistently, and it will be consistent with justice, which require a careful and impartial and correct trial. If selected on the jury, unless otherwise, you will be permitted to separate for recess, for meals, and at night. Now, at this time, I have an administrative matter that I must attend to before administering to you the second oath. I need to administer to you the first oath. And so I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, "I do." Now, do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be asked of you by the court or under its direction, touching your service and qualifications as jurors, so help you God? Please say, "I do." Okay, you may put your hand. The law requires that each of you must possess certain qualifications before you may be considered for service as a jury. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on the jury, the case could be retried, that is, a mistrial can be declared, and you may be held in contempt of court and placed in jail for up to 180 days and be given a fine that does not exceed $500. Now, the way I'm going to ask the questions, I will ask a series of questions. I do not want you to answer the question out loud. Just answer the question to yourself. And when I finish asking the last question, and then I will ask, is anyone disqualified under the law? If you think that you may be disqualified under the law based on the answers to one or more of the questions, then I will ask that you will come up before the bench so that we can discuss the matter more privately. Now, when I say more privately, what I'm talking about, first of all, we are airing currently on YouTube. I will turn the YouTube off. I will turn off this microphone so that they can't hear. And then we have what is called a noise sound device. It sounds like this. Okay. And so once all of the noise sound device is turned on, YouTube is turned off, and the mic is turned off, we would ask that you come before the bench. You're going to stand on this side because our court reporter is sitting to my left, and there's a microphone that he has so that he can hear everything that's being said. So again, before we get started, I will ask a series of questions. I do not want you to answer those questions out loud. Please answer the questions to yourself. And then once I finish asking the last question, I will ask if anyone is disqualified under the law. If you think that you may be disqualified, you can simply raise your right hand and we will ask that you will come up one at a time. Okay. First question. Except for failure to register, or you're a qualified voter in this county, that is Jefferson County, and in the state of Texas under laws and constitution of the state of Texas. Have you ever been convicted of theft or any felony? Or you're under indictment or legal accusation or on deferred adjudication probation for theft or any felony? Now, I always pause before I ask this next question, and I need to inform you that I'm required by law to ask this question. I am not trying to pry into your personal affairs. And the next question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? And this is the last question. Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Is anyone disqualified under the law? If you think that you may be disqualified, please raise your right hand. Let the record reflect that no one raised their hand. Now, I will move to exemptions. I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to. but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just remain seated. And I will ask these questions in the same manner that I asked the previous set of questions. That is, I will ask a series of questions. Please do not answer these questions out loud, just answer them to yourself. And once I ask the last question, I will then ask if there's anyone who would like to claim an exemption. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in Jefferson County during the 3-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States Military Forces serving on active duty and deployed to a location away from your home station and out of your county of residence? Is there anyone on the panel who would like to claim an exemption? Let the record reflect that no one on the panel is claiming an exemption. Now I will finally move to excuses. With the excuses, I will not be asking any questions. I will simply make 3 statements. And if any one of these statements apply to you and you would like to claim an excuse, when I ask if there's anyone who would like to claim an excuse based on these 3 questions, just please say so. First statement. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the defense and without the consent of the state. And the final statement. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who will be claiming an excuse? Let the record reflect that no one on the panel is claiming an excuse, no one is claiming an exemption, and all members of the panel is qualified to serve as a juror in this case. Now, again, ladies and gentlemen, I would like to again welcome you to County Court at Law number 2, Jefferson County, Texas, where I'm the judge here. The case that we have before us today is styled the State of Texas versus Martin Enrique Gamez Jr. The time now is 3:16 p.m. on today's date of June 8 of 2026. Ladies and gentlemen of the panel, you have been summoned to this court as prospective jurors in this criminal case. The defendant, Mr. Martin Enrique Gamez Jr., is sitting at the table before you. with his attorney, Attorney John Macy. The state is represented in this case by Assistant Criminal District Attorneys, Attorney Cornelius Williams.
Good afternoon, everyone. And I will be joined by Terrence Nixon from the District Attorney's Office.
Okay.
Welcome.
Our court reporter in this case is Mr. Sebastian Aguilar. He's sitting to my left. He will be taking down everything being said, so speak up when you're asked questions and when you're answering questions. The bailiff, Ms. Brenda Mosley, you met her earlier. She is the bailiff in County Court at Law number 2. Now, the defendant stands charged by information with the Class A misdemeanor offense of violation of bond/protective order. And as I mentioned to you earlier, this is a Class A misdemeanor. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, and experiences, and attitudes. In questioning you, they are not trying to meddle into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, please say so. And I will ask you to come up to the bench so that we may discuss it more privately. Is the state ready to proceed?
Yes, Your Honor.
And is the defense ready to proceed?
Yes, Your Honor.
Okay, Ms. Nixon or Mr. Williams, which one will be doing it? But okay, Ms. Nixon, the panel is yours. And I'll be keeping time. 30 minutes enough?
Yes, Your
Okay, you may proceed.
Honor. Thank you for coming. What this process is, it's 4 hours, and what it means is just the truth. So what we want you to do is to be vocal and speak the truth and let us know how you're feeling about the questions we ask, and if you have any questions about the questions. First of all, I want to ask, does anyone know anyone here present? Do they know Mr. Gamas, the defendant? No? Do they know Mr. Racy? Aaron Nixon? No. Probably not, I'm not from around this area. Does anyone know Mr. Williams? No. Does anyone know the judge? No. Or any other side? No. Wonderful. Okay. The burden of proof is on the state, and what we're asked you to do is to listen in, examine the facts, apply the law to those facts, and follow the law. And what we're doing today is a violation of a bond condition. And what we need to ask you is that you need to determine these facts if they can prove beyond a reasonable doubt that the defendant is guilty or not. And what beyond reasonable doubt is, there's no definition of it in the state, in our books and everything. What we're gonna ask you to do is use your common sense and your life experiences to make the determination of whether facts are proven and whether the law is followed. Okay, first of all, let me ask you this, is there anyone here who has ever been a victim of crime? No. No? No? Does anyone ever know any victims of crime in their family?
Yes, I was, when I was very young, I was attacked. I mean, do I need to talk to you about that, or?
I'm just asking because I wanted to ask the question. So-
Yes, I was.
Okay, Miss Levens? Okay, so Miss Levens, when they make conditions of bond, what they're doing is they're making conditions on, and some of them are to protect the bondsmen, some are to protect the victims and to protect the witnesses. So saying that, how important do you think it is for a defendant to not violate a bond condition? As far as,
It's very important to not violate
correct,
bond condition.
Because it's important that we protect victims and witnesses,
Yes.
correct?
Yeah.
The good thing about bond conditions is also they help to protect the defendant, because they line out exactly what they should and shouldn't be doing. Okay. Okay, so whenever we're presenting evidence, the types of evidence, what are some of the types of evidence you'd like to see to prove a violation of a bond condition? Does anyone have any types of evidence they'd like to see? Okay, just calls. Mr. Driver? What kind of evidence would you want to see in a case of for a bond condition violation? What kind of evidence would you like to see?
Yes, factual proof.
Actual proof. And would that be something that you can, like a visual proof, like a body worn camera, video?
Right.
Okay. What about officer testimony?
Yeah.
Okay. Witness testimony?
Yeah.
Okay. Does everyone else agree that those are the items you want to see? Does anyone have anything else they'd like to see? For a bond condition?
Like how much evidence they have. I mean, as far as like he said, video or whatever, if they have something that's legit or whatever.
Okay, okay. Is there anyone here who could not sit in judgment of another person? Have any issues like religious convictions?
I'm just having a hard time understanding you.
Oh, I'm sorry. Let me talk up. I have kind of a quiet place. Is there anyone here who cannot sit in judgment of another person? Thank you very much for your participation today. I look forward to working with you.
Mr. Macy? Panel's yours.
Thank you, Your Honor. Good afternoon. My name is John Macy, as the judge told you earlier. And I represent Mr. Gomez in this case. You've been asked to be jurors. Or potential jurors. You're actually a jury panel. Of an IR panel, if you wanna name it. This is the only opportunity we have to talk to you, and you talk to us. And we can ask you questions, and you can ask us questions. But after this, then we won't be able to talk to you at all. So if you see us out and about, and we kind of walk by you, and other than maybe give you a smile or something, try, don't hold it against us, not just us, but them. They can't talk to you either. Because we need to make sure that it appears that everything is happening the way it's supposed to, and we're not supposed to try to influence you. You're supposed to, whoever ends up on this jury is supposed to listen to the evidence and consider the evidence that the judge admits as evidence. And then that's what you're supposed to use to determine whether the state proved their case beyond a reasonable doubt. So if I was gonna ask you, and I'm gonna, what do you think a juror's job is? Well, let's just start with Mr. Driver. What do you think a juror's job is?
To give the best results of giving information given in court.
Okay, and you're gonna have to bear with me, I wear hearing aids, I don't hear very well, even with my hearing aids, and sometimes I might ask you to repeat something. Because I just can't hear you, and know something else too. You're speaking toward me. But I might ask you, Mr. Driver, what I just said about what you think a juror's job is. But, sorry. You're, hey, you're Miss Dickerson?
That's
I'm sorry?
Dixon.
Miss Dickerson may not have heard you. So try to speak up, because you're not just talking to me, but they might want to be interested in what you have to say as well. Because they may agree with you and they may not, okay? So what I think the juror's job is, like I just said, was that I think you're supposed to listen to the testimony, which is, there's certain types of things that aren't evidence in a courtroom. Some of it is testimonial evidence, some of it is physical evidence, and some of it is demonstrative evidence, okay. Testimonial evidence is a little different than other kinds of evidence, because testimonial evidence is evidence you're getting from a person. They're giving their testimony as to what they believe happened, right? And so the juror's supposed to decide whether they believe some of what the person testifying says, all of what somebody says, or some of what they said. That's up to y'all to determine that, because y'all are what they call, the jurors are what they call your judges, just like the judge is the judge, but y'all are the judges of the facts. Y'all determine what happened in y'all's belief based on the evidence that was presented. Y'all believe, y'all need to determine what y'all think the state proved to you. And some of that can be used by testimonial evidence, or if some physical evidence is actually admitted, then you can consider that. And I'm holding up my pen, if this mattered. And it was part, the judge, the state or defense tried to use a pen as evidence, and the judge admitted it, then you could consider the pen. If they didn't, if we didn't, the judge didn't admit it, then not supposed to consider it. So right now, you know that Mr. Gamez is accused based on what Ms. Nixon said, was he's accused of violating the protection, right? Or a bond. So if I asked you right now to decide, is Mr. Gamez guilty, not guilty, or would you want to, who here thinks he's guilty? Don't see anybody's hands. Who here thinks that they want to wait until they hear the evidence before they decide? Yeah, I see everybody raise their hands. That's kind of that's my trick question of the day. Okay, I'm not here to trick you. They're not here to trick you. We're not here to trick you. However, that is my trick question of the day. This trial hadn't begun. And so there's no juror sitting over there, and there's no juror and there's no evidence that's been presented in this trial yet. So I believe that what your answer should have been is not, I want to wait till I hear the evidence before I decide. The answer, the correct answer should have been, he's not guilty right now, because there's been no evidence to prove that he's guilty. Right? So if I ask you again, would you hold the state? Are you gonna hold the state to their proof? Are you gonna presume that he's guilty unless we prove otherwise? Will you promise me you'll do that? And I see shakes. Is there anybody who can't do that? I don't see any hands. How easy is that to do? Let me back up. I don't like my question I just asked you. In a trial, what's gonna happen is 6 of y'all are gonna end up being the jury. And then the state is gonna go and put on their evidence. And they're gonna put on the evidence they think they need to put on to prove that Mr. Gamez did what they assert he did. And then, once they rest, then the defense has the right to put on evidence, but doesn't have to. And we don't have to do anything, because the law says that Mr. Gamez has constitutional right to, he's innocent until they prove beyond a reasonable doubt that he's guilty. So if you have some reasonable doubt, once they're done, that by itself is enough for you to find Mr. Gamez not guilty, which is similar to the question I just asked you about. He's innocent. No, there's been no evidence. That alone is enough to find him not guilty. Just because he's charged, accused of doing something, doesn't mean he did it. Okay? So, how easy is that to do? Mr. Nguyen, do you think that's easy or hard for a juror?
If the jury is being unbiased, yeah, I could see that it'd be easy.
And I didn't finish, I guess, let me finish with what I was, my thought process. Okay, so they rest, and then we either put on a case or not. And then I rest. And then there'll be some kind of, then the judge will, there'll be some kind of closing arguments. The judge will read the charge to you all, to tell you what the state had to prove. Because right now, you don't know what the state has to prove to find Mr. Gamma is guilty of what they accused him of. You think you have some sense of a charge, right? But the judge is going to tell you exactly what they're required to prove. And then once that happens, you go back into the jury room, the jury deliberation room, you pick a foreman, and then y'all deliberate to try to decide whether, based on the evidence that was presented, do y'all think that they proved their case or not? Okay. And then you reach a verdict, and then you come back out. If y'all don't believe the state proved their case beyond a reasonable doubt, and they didn't give you a definition of that, and they're not gonna, and I'm not gonna either. But if you have some reasonable doubt, if you use that term, you should use your common sense and reason. If you believe that you have a reasonable doubt as to something they were supposed to prove, what is supposed to be your verdict?
Not you.
Not sure. So when I asked Mr. Lynn, how easy did I think that's gonna be? Mr. Martinez, right? There you are. I'm sorry, hold on, look over there. You think that's easy or hard?
Can you repeat the question?
Well, if I can. Remember that I believe that you're supposed to wait until you've heard all the evidence. All the evidence is the judge admitted. And then he tells you what they have to prove. And then you go into deliberation room, and then you start evaluating the evidence that was admitted based on, now you know what they had to prove. So my question is, you think it's easy or hard to wait until the end to make that decision?
I think it's best to wait till the end.
I'm sorry,
I
what?
think it's best to wait till the end to make that decision, so you get a full scope
Right,
of the overall situation.
understand. And I appreciate that. I don't know if y'all heard him. He said he thinks it's best to wait. And I agree with that. Actually, I'm asserting that that's what I'm asking. But how easy is that? Everybody, let me ask you that. Great. When you grow it up, right? You learn based on your experiences how to deal with people, right? And so when you're doing that, is it a good idea to kind of make a decision as to whether or not it's safe to even talk to somebody before you actually go up there and try to talk to them? It's human nature, isn't it, to and you're taught from while you're growing up, that you make evaluations about people when you first see them, for your own sake, for your own peace of mind, and then make determinations as to things. And I'm suggesting to you that because it's human nature to do that, you might have already walked in here and already decided you think Mr. Gomez is guilty. Or not, right? Hopefully not. But it's different. I'm not trying to suggest that you should believe Mr. Gomez not guilty by looking at him, other than the fact that that's what the law says. The law says he's, as a citizen accused, he's presumed not guilty. He's presumed innocent until you're proved, until the jury decides that they have enough evidence. I think it's guilty. And that's what I'm suggesting to you. It's not hard. Hard to sit back and wait and not judge. For example, she said, Ms. Nixon asked about what evidence do you want to, would you like to see when, somebody is accused of, violating a protection order, wouldn't you want for them to, do certain things, to protect the community or to protect the people and all of that? Remember those questions? And one of the first things I have to prove is that there was a protective order in the first place, right? And that's why I said you have to wait until the judge tells you what they have to prove. Can't presume the others protective order even violated it for them. No, those are what they call elements of the offense that they have to prove. And if they didn't prove that to you, because it's not good enough to have certain for, as evidence. I've seen prosecutors do that, but they do this, but I've seen prosecutors, and what they're talking about is usually they're trying to suggest that they don't have to prove everything. That they have to just prove beyond a reasonable doubt. They don't have to prove beyond all doubt. And a lot of times they use a picture, of a puzzle with some pieces missing. Right? And that puzzle, you can see that there's a picture of a gun, except for there's some pieces missing. And they say, and they use that to suggest that they don't have to prove everything. They only have to prove enough to get you to prove to you beyond a reasonable doubt something. And I would agree with that, however, in that scenario, if they use something like that, it's easy to, the picture of a gun is they're trying to prove a physical element, okay? And that's not all that's required to be proven to a jury in any kind of case. There's other elements that they have to prove beyond a reasonable doubt. And that's why I'm suggesting you need to wait and listen. And wait till you get the charge from the judge so that you know what they have to prove. And y'all will do that, right? Best you can? Okay, I appreciate that. And I don't mean to harp on this, but I've had people, I've known of people in Venires that I had somebody in Hardin County, an attorney, I was supposed to go up and pick a jury on a felony case. And an attorney stopped me that I knew and said, hey, watch out, because this person, I knew this person and I saw her and I asked her, hey, what are you doing here? She's going, oh, I came to burn somebody. I'm on the jury. Hey, you just want to find somebody good. I had also, is there anybody here who believes that Mr. Gomez wouldn't be here if he didn't commit an offense? Right? Anybody here believe that? You know he's accused of, right? Because otherwise he wouldn't be sitting. This goes back to the question I asked about when I talked about the presumption of innocence, so to speak. And then y'all all said, oh yeah, I guess he is innocent till they prove guilty. I should have not said, I'm on wait, I would change my answer to he's not guilty right now. Speaking of jury. In Hardin County again. I gave that. Oh, the same thing I just asked y'all about. Well, you know, somebody's, the law says they're innocent. Still proven guilty. One of the Von panel said, no, I find he's guilty. Yeah, he wouldn't be here otherwise. I said, well, you understand. And I told her the same thing I just told y'all. Didn't matter to her. Did she have a right to that opinion? Actually, I think she did. You have the right to believe whatever you believe. Okay? And I appreciated her telling me, because it would have been just as easy for her to not say anything. And then what happens if she'd have been on the jury? That's what we're trying to avoid. That's why we're doing what we're doing here. We're trying to find people who will be fair and impartial to them and us. Right? And so that's what I'm looking for y'all. I'm just looking for somebody who's, if you have a problem, that's fine. It's your right. You have your own life experience, right? I don't know which ones. I know you were asked about, you ever been a victim of a crime or know somebody that was a victim of a crime? And nobody said anything. But if you did and didn't volunteer that, would we know? And everybody's kind of looking through deer headlights. I know you don't want to answer. We wouldn't know. So that's why it's a leap of faith that y'all are gonna do what the law requires you to do, which is to be open. From my perspective, I'd like you to be at least open to the possibility that Mr. Gammons didn't do what they claim he did. It's not supposed to be that. I believe that y'all believe that. But certain offenses, I don't think this is one of them, but certain offenses have a certain stigma to them. And you might want to, for whatever reason, find a person guilty in a certain kind of case, just in case they did. Not supposed to do that. I didn't see that there's nobody that I saw that ever worked for the district attorney's office, right? In here. I did see that a couple of y'all worked, at least in the past, for the Texas Department of Criminal Justice. Who was that? And y'all were, prison guards, or you were prison guard?
Yes.
And you were,
Reentry.
I'm sorry, what?
I am reentry. Reentry. I'm sorry, reentry.
Reentry. Oh, I'm sorry. Okay. So, so that's, when you're talking reentry, you're talking about, helping somebody who's done with their time to reenter the society.
Correct.
Okay, gotcha. So there's different people that need that, different kinds of services from you. Do you still do that or you're tired?
I still do that, and we also do it for the ones that haven't been released, they're inmates in prison as well.
And obviously, there's different ones that have, obviously, for example, certain people have been convicted of sex offenses who are required to register sex offender for the rest of their life. And you assist them in getting that going too. So there's different people that have different issues. And you know, and you were what, prison guard? Or-
Yes, sir.
And you're retired.
Yes, sir.
Does any of that, working for the Texas Department of Criminal Justice, have would affect your ability to be a juror, a fair juror in this case? You think?
No, no.
I wouldn't either, but I was just curious.
You have 5 more minutes.
Thank you, Judge. When we talk about proof beyond a reasonable doubt, you think that's a high standard? I'm sorry, you're Mr. You shook your head. Your name is Mr.
Absher. No, PT, Absher.
Oh, Mr. Absher, I'm sorry, yeah, I didn't, I'm terrible at the name thing, my chart, Steving. You shook your head when I asked you if you thought that was a high standard, why did you do that?
Like it's just gotta go slightly one way to prove innocence.
Right. You know, we don't have to prove he's innocent, we have to prove that he violated his, he have to prove beyond a reasonable doubt in all the elements, okay? There are certain standards of proof in criminal cases. There's the lowest one, which is, I don't remember if I remember the name of it. There's, I'm sorry. There's it's a scintilla of evidence. Means almost nothing. But it's a standard of some sort. And then the next one would be something like reasonable suspicion. And the reasonable suspicion is what a police officer needs to even just approach you to see if, try to do some investigation. However, of course, a police officer can say, well, no, they voluntarily talked to me without me having a reasonable suspicion or whatever. But then there's probable cause. That's the next one. Probable cause is what you need to arrest somebody. If you arrest somebody, does that mean you're guilty? They're guilty. No, it means that they had probable cause to believe that they may have committed an offense. And then the next one is, actually, the first one they use in a trial. It's in a civil trial. It's preponderance of the evidence. Preponderance is more likely than not. 50%, 50-50 is not a preponderance. It's not even a preponderance. A preponderance is tilting the scale, just barely. That's a preponderance. That's what they require proof of in a civil case. And then the next one is clear and convincing. Clear and convincing evidence is the evidence that's required that is really getting serious. Because what they're trying to do is take away somebody's parental rights in a family law situation. You're gonna take away your child. They better prove by clear convincing evidence that something happened that was serious enough, make you believe it enough to do that.
You have a minute?
Thank you. And then the last one is beyond a reasonable doubt. It's the most burdensome proof. Not the, oh, it's an easy standard. No, it's the hardest one for them to. And that's the standard because you're taking away potentially a citizen's liberty. That's supposed to be one of the most important rights we have in this country. What our country was founded on. And I would suggest that that's the burden I'm asking you to hold them to in this case. Anyway, I've talked long enough. But I appreciate y'all's listening to me, y'all's time, and we look forward to presenting the case and the six to you that end up on this jury. Thank you.
Good. Okay, ladies and gentlemen, I'm gonna ask that you would step outside. You can go out either door. We may have to call some of you back in for some follow-up questions. So at this time, everyone please stand as the panel exit the courtroom. You may exit.
Front doors open.
Okay, members of the jury. Let you finish. Okay, members of the jury, at this time, I must administer to you the second of the two oaths. I need each and every one of you to raise your right hand, and once I finish administering the oath, please say I do. Do you and each of you do solemnly swear that in the case of the state of Texas versus Martin Enrique Gamez Jr., you will a true verdict render according to the law and the evidence, so help you God? Please say I do.
I do.
Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts comes from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judge of the credibility of the witnesses and the weight to be given their testimony. You may believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorney will probably make objections to questions asked by the other attorney of witnesses and objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply overrule or sustain the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather his equipment and take it with him. And the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument until you retire to deliberate. Do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of this courtroom anything about the facts of the case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper or on social media or television or watch television reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. Ladies and gentlemen of the panel, those of you who were not selected to serve as a juror in this case, first of all, on behalf of the citizens of Jefferson County and behalf of the staff here in County Court at Law Number 2 of Jefferson County, Texas, I'd like to thank you for your time and attention. I know that some of you may be disappointed because you had hopes of being selected as a juror in this case. But we only have a limited number of jurors that can be selected. I do not want you to think that you wasted your time. I know that when you came here this afternoon, you were enthusiastic and had hopes of serving on this jury. But I can assure you, you did not waste your time. As I mentioned to you earlier, the court had 3 dockets this morning. And I've explained to you, we had a trial docket, an announcement docket, and we had a pretrial conference docket. Now, when we add up all of those cases that was on the docket, starting at 9 o'clock, we probably was in the neighborhood of 60 cases. And so with that in mind, a lot of cases got disposed of. In essence, a lot of things were taken care of. I mention that because what you don't understand is that months ago, when cases get filed, lawyers do investigation, the district attorney have conferences with defense attorneys. They make offers to settle the case. Sometimes some individuals say to themselves, you know what, I'm going to reject that offer and I want a jury trial. Sometimes some people say they want a jury trial because they believe one or two things is going to happen. One thing they believe is maybe the jury is not going to show up, or 2, the witness is not going to show up. But on days like today, when jurors show up, witnesses show up, it is not uncommon for some of those individuals to say to themselves, you know what, that offer that the state made to me a few months ago, it looks pretty good right now. And so it's because of people like you who've taken time out from your busy schedules to come down here and to serve as jurors. So you did not waste your time. I know that when you came down here this afternoon, you were looking for County Court at Law Number 2, you probably looked over the door and you said, this is, County Court at Law Number 2, Judge Terrence L. Holmes presiding. And you say, well, I'm in the right place. This is Judge Holmes' court. No, this is not my court. This is your court. This court is for the citizens of Jefferson County, and you're the citizens of Jefferson County. And so anytime you're in the area of your courtroom, you can come and have a seat in your court and see what goes on. And I'm sure you'll find it very interesting. Now, you'll be able to sit in that area that you're sitting in behind the wall. We call that the peanut gallery. But it doesn't mean you can bring peanuts in here and eat, because this is not the Texas Roadhouse. Okay? But you can come and have a seat in your courtroom and see what goes on in Jefferson County. And as I said to you earlier, you'll find it very interesting. Now, your jury service is concluded. Our bailiff, she has some letters. She has a letter for each and every one of you. And if you feel free, you can drop us a line, talk about your jury experience. And before you leave, I usually give each and every one of the jurors a handshake. I do know that we still have COVID in our neighborhood, so I can't give you a physical handshake, but I can give you what I call an air handshake. So on behalf of the citizens of Jefferson County, behalf of staff here in County Court at Law Number 2, thank you for coming out today. Your jury service is concluded. You're free to go, and each every one of you have a blessed day. You're welcome.
Good job. It's good to see you. It's been a long time. Did you let you go? I didn't, I didn't.
State, you're gonna start your testimony on tomorrow afternoon, is that correct?
Would the court like the openings today, Judge, and would you complain?
If you would like to,
We can do
if
that.
that's what you would like to do.
We're
You're
gonna
gonna, you're gonna read his complaint and then we'll do our opening statement.
If,
That's fine?
if that's what court wants to do, that's fine.
Okay, that's fine. Okay, at this time, ladies and gentlemen, of the jury, the state is going to, read the information. And just for a, brief explanation. In felony court, they have what is called an indictment. In misdemeanor court, we call it an information. It's both the charging instruments, but we call ours an information. A felony court is an indictment once they get indicted by a grand jury. And so he's going to read off the charge on the information. At this time, Mr. Gamaz, would you please stand in, Mr. Okay, at this time, you may proceed, Mr. Williams.
Thank you, Your Honor. In the name and by authority of the state of Texas comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and present in and to the County Court at Law of Jefferson County, Texas, that in Jefferson County, Texas, Martin Enrique Gomez Jr. Hereafter styled the defendant heretofore on about July 19th of 2025, did then and there intentionally or knowingly violate the terms of an order issued by Magistrate Judge Mark DeRuin of the 252nd District Court of Jefferson County, Texas, on July 17th of 2025. Under the authority of Article 17.292 of the Code of Criminal Procedure, by intentionally and knowingly going near Shanna Hurd, a protected individual described in the said part, against the peace and dignity of the state.
And Mr. Gamaz, how do you plead?
Not guilty.
Okay, you may be seated. State at this time you'd like to make your opening statement.
Yes, sir.
You may proceed.
On Saturday, July 19th, over there in the 3400 block of Central Boulevard in Nederland, Texas, the defendant, Enrique Gomez, was released from jail. He was released from jail, ladies and gentlemen. We believe that the evidence will show, because just 3 days later, 3 days before, he had been arrested. What was he arrested for? For threatening to kill Shanna Hurd, a terroristic threat. For you see, we will show that those facts are inextricably intertwined, because when he did get released from jail, Judge Mark DeRuin and gave him conditions. What were those conditions upon his release? You cannot go within 100 feet of the complainant, Shanna Hurd. It's as simple as that. But what I also want you all to focus on, again, where it happened. In a 3400 block of Central Boulevard, it is a RV park. Domestic violence affects not just the people in the relationship, but the neighbors, but the other people who live in that RV park. The evidence will show that we have a 911 phone call. Police officer arrives on the scene, and who do they see in violation of the order? The defendant Gomez. But you know what? When he got released on that Saturday, on July 19th, within 6 hours of being released, he violated the law. We submit to you that that happened here in Jefferson County, Texas, but it was done by that man. And once that was done, that crime and the elements will be proven beyond a reasonable doubt. And at the conclusion of this case, and while we ask you all to continue to listen to the evidence, as was pointed out by Ms. Nixon, all you have to do, ladies and gentlemen, is use your common sense and your experience. That will be the filter. And I submit to you, I place before you that that filter will be proven beyond a reasonable doubt. Thank you.
Mr. Macy, would you like to have your opening statement, or would you like to reserve it?
No, I'll go, Jeff.
Okay, you may go forward.
Thank you, Your Honor. Good afternoon again. That was a very passionate opening by Mr. Williams. We're here to decide, and you're here to decide whether they prove this case that Martin Gomez violated the protective order. Not whether or not something occurred 3 days earlier that ended up getting him arrested. Because from a realistic standpoint, what does it take to get arrested for an assault, family violence? You may not know that. It's just somebody saying, hey, you know, you get an argument with your spouse or whoever, your girlfriend or boyfriend, whoever it is. And tempers flare. And all they have to do is say, hey, person is did something to me. They threatened me, they hit me, they did whatever. And then the police show up. So what do? Were they there? No. Do they know what happened? No. But they have some information that there's some altercation. Okay. So what do? They need to separate the parties. How do they do that? As a general rule, what they do is they arrest somebody and take them to the jail. Does that mean they did it? No. But they got arrested for it, taken to the jail for it, and now all of a sudden they're in jail. And then they eventually get out of jail, right? Because he's got out of jail because he's sitting right there, right? And they want you to believe, oh, well, he knew. Because remember, he's charged with intentionally or knowingly violating a protective order. So what does that mean? It means that they have to prove that there was a protective order, and that he knew there was a protective order, and that he intentionally or knowingly violated it by doing something. Okay, so just because they saying all this stuff happened, well, that's why you're here, because you have to listen to the evidence. And when you're listening to the evidence, you need to consider who's telling you what, and did they know? Were they there? Do they really know what they're testifying about? Because if it's police officers, they weren't there, right? Anyway, I think that I would hope that you just not make a rash decision based on emotion. Wait until you hear the evidence, what's presented, and then you're gonna get the charge, so the judge is gonna tell you what they have to prove. And then we're gonna discuss that at the end, and they're gonna suggest that they proved it. And I'm gonna suggest that they didn't, and then y'all are gonna decide. So I'd appreciate it if you would, I know y'all are doing your best, and all you can do is what you can do. And you're gonna listen to the evidence, and I think that once you do that, you'll have some reasonable doubt at the end to find Mr. Galen is not guilty. Thank you.
Okay. And Mr. Williams, we're going to resume on tomorrow with your first witness.
That'll be correct, Your Honor.
Okay. Let me ask you, like to start out with usual 1:30 time?
I'm sorry, Judge, you said.
You would like to start at the usual 1:30?
Yes, sir.
Respectfully, I would request 1:45, Your Honor.
Okay, 1:45.
Zoom hearing.
Okay,
Just did.
okay, so we'll do 1:45.
Unfortunately.
Okay, so ladies and gentlemen of the jury, we're gonna ask that you come back on tomorrow at 1:45. We just started the beginning of the trial. On tomorrow, the state is going to present their case. They're gonna be calling their witnesses. And so we need to have everyone here before 1:45, and you're gonna sit outside the courtroom and you'll wait for the bailiff to come get you. Now, I must inform you that they may have a matter or two. Sometimes we have our cases in the morning, and sometimes they go over, or an issue may come up, even in this case, that will require us to start a little later than that. But the goal is to start at 1:45, and we ask that all of you be here at or before 1:45. Okay? So you can take the tags home with you. You make sure that you wear those tags at all times, because those tags identify you as a juror in this court. All right? So we're gonna ask that you stand. You're free to go. Everyone, please stand as the jury exits the courtroom.
I didn't know that was.
Or to be in recess.